the nightly news. Tonight's story is over Troy Leon Gregg versus the state of Georgia in 1976. In 1972, however, the Supreme Court ruled that the death penalty systems that were in place at the time were unconstitutional due to violations of the Eighth Amendment's prohibition on cruel and unusual punishments. In response to this decision, many states changed their death penalty system. 4 years later, in Gregg versus Georgia in 1976, the court reaffirmed the death penalty as constitutional.
Or problem posed by the case. The death penalty was thought to be unfair by the petitioner, who was charged with committing armed robbery and murder on the basis of evidence that he had killed and robbed two men. Or various positions that can be taken on the issue. For death penalty, Constitution and fares, not only because he murdered two men, but because it went through a two-step review involving the jury and appellate court, which is still being used today to ensure maximum amount of fairness and following of constitutional rules and boundaries. Not for the death penalty. Leon Gregg urged the court to go further than it had in Furman by holding once and for all that all capital punishment was cruel and unusual punishment that violated the Eighth Amendment.
The Supreme Court ruled that capital punishment is constitutional in this case because the death penalty does not violate the 8th and 14th Amendment. If the jury is in agreement with standards to direct and limit the sentencing discretion, and the jury's decision underwent and is subject to meaningful appellate review, then the death sentence may be constitutional. If the death penalty is mandatory, such that there is no provision for mercy based on the characteristics of the offender, then it is unconstitutional.